But now the petitioner did not challenge any rule.
They filed an IA. That IA
Amendment.
Yeah, fine.
Amendment is fine. So then before
IA
that, madam, hold on IA number so and so.
And amendment copy is also filed.
1 minute. Hold on IA number 3 of 2023, taking into account the nature of proposed amendment and for the reasons stated therein, same is allowed. Let amendment
That is what
the neat copy has already been. This court wide a common order passed in WP number 21268 bar 2023. Madam, you can't have a spare copy of the judgment. You can't have. Madam, today judgment is delivered. Today judgment is delivered. The copy is, you cannot take a printout of operative portion. Then where is it?
no.
Then make a photocopy if not available, or ask him to give a printout additional copy. I will henceforth ask him to prepare in 2 copies. This court
May I
might-
take one or may I read?
Of course, I mean, we don't know why it has been taken inside, Mr. Rao. It's very strange here. I'm sorry. With this judgment is ready and it is signed, pronounced, and they have taken it inside. Why, madam? Who has taken? No, but that's correct. But they should see, right?
Allowed to
Then
system, you should have the permission of the court to peruse the judgment. We would have given it. Normally, once it is signed for being initialed on other pages, it is kept on my lord's table. That can be a complaint.
No, may I take the copy home? That's
We'll try to upload it today itself. If you want to peruse, normal system is they will have the permission of the court.
Yes.
We may be permitted to peruse it. You know what happened in ITC judgment before the Honorable Supreme Court? Before, without my Lord's Justice Rumapal's permission, the order was taken out and taken to Xerox Center.
1 minute, Mr. Rao. I will sign it just now so that there is no problem. No, but I thought that it's available and you must have seen it. See, with great difficulty, we found out where it is kept ourselves. The author also has no access to the judgment. it will be given to me. You know, now, people, it's not in the city. But this, he wants a copy. No, he will already just send the instructions, it will be uploaded in Gmail. So, people get to implement this. Yes, it's one more thing is will be. Implement, implement it is not replicated in that. It will be done. Now it will be done. I've seen.
Soft copy they will not వీళ్ళకి చెప్పండి సాఫ్ట్ కాపీ డంప్ వేసేయండి డంప్ వేసేసి సో దట్ లెట్ దెమ్ స్టార్ట్ getting it in the website that this
Tell whatever, whosoever, you will be here till 1:30, then who will do it there? Tell.
we found already for that some possibility. Okay.
Yes, madam, what? White common order dated 29/8/2020, passed today. Pass order dated 29/8/2023, that is today, passed in WP number 21268/2023 and other connected matters, has already read down rule 33B of the rules, right? Whatever rules, full stop. Paragraph. For the reasons assigned by us in the aforesaid common order, it is directed that in case petitioner produces residence certificate issued by competent authority of the government of Telangana within a period of 1 week from today before the university, the petitioner, the university shall treat the petitioner as a local candidate for second round of counseling. Right?
And already we treated, your seat was allotted.
Right. So shall treat the petitioner as a local candidate, full stop. Needless to state that the claim of the petitioner as local candidate for admission to MBBS stroke BDS course shall be considered as local candidate for the academic year 23-2024 as per his merit.
Yes. Deeply applied. Page number 28, I filed the local certificate as well along with.
We are not the university granting admission.
Yes, madam. Deeply obliged.
Accordingly, the petition is disposed of. Madam, get this order typed now and give it. In another case, it is required. Accordingly, the writ petition is disposed of. Please have Mr. Rao.
Copy by tomorrow, your lordship, so that.
Today,
Yes, madam.
this is which case, madam? 56.
Deeply obliged.
May I please, members? Yes, please. May I please, members? This is the public interest litigation matters which is
Counter.
allotment of counter has been
Counter is
filed.
filed, my lord, they want us, they are seeking leave for withdrawal, like.
So public interest litigation, so you cannot take it.
Not.
No, my lords, the counter has been filed, my lords, by them. My lords, basing on the counter, this may be disposed of, my lords. Basing on the counter filed by Advocate General, my lords,
Disposed of.
may be closed.
What is the counter, Mr.
My lords,
Advocate?
counter is, my lords, this is in fact, my lords, transferred by Yadagiri Gupta Temple
Who is
Development
that,
Authority.
Counter.
The my lords. It's virtually an exchange of the property, my lords, the trust.
Please. In this petition which mark the presence with consent of the parties, same is heard filed. In this writ petition, petition filed as public interest litigation, the petitioner inter alia seeks petitioner inter alia assails the validity of action of Yadgiri Temple Development Authority
That's very good.
in executing a registered sale deed dated 5/9/2019 in respect of land measuring 2.30 guntas of survey number 172 situated at Gundalapalli village, Yadgiri district. What so then can be both they exchange it because they when the government taking everything we can put para 4 and 5.
It is only exchange for the nominal value,
Fine.
but taking the cost of
All
construction.
right. Has the respond number 4 in para 4 and 5 of the counter has taken a stand which is extracted below for facility of preference, paragraph 4 and 5. Right. Thus it is lying below. Thus it is evident that the land that the allotment of land has taken place
In exchange of the
in exchange of an existing land,
Existing building, my lords.
existing building belonging to
Trust.
belonging to Yadgiri, no, belonging to respondent number 6, this namely so and so.
And consideration for land also is paid, my lords, 16 lakh and all. In addition to that, 16.50 lakh, there are 6, my lords.
In addition, the consideration for exchange is 16.50 lakhs.
Yes.
Full stop. Full stop. Therefore, what you submit, it be disposed of.
Yes, sir.
In view of aforesaid stand taken by respondent number 6, learned counsel for the petitioner submits that the writ petition be disposed of. Paragraph. In view of stand taken by respondent number 4 in paragraphs, aforesaid paragraphs, it is evident that the action of executing a sale deed cannot be found fault with in the facts and circumstances of the case. Accordingly, petition is disposed of, dismissed, disposed of, disposed. Yes.
Obliged.
Obliged.
Yeah.
Lord, it's
Ready?
Lordships, today morning I have filed a reply, my lord, will along with substantial material papers. Kindly accept 230, my lord. Kindly accept 230.
But my lord's order on 24/8 was recording my submissions made. The lordships directed me to file an affidavit. I have filed an affidavit incorporating the statement which I made before my lords. But
But what he has filed, we don't have the benefit.
now he has filed just now. I served on reply.
Day after.
Yeah.
Mr. Prabhakar, learned counsel for the petitioner submits that today what you have filed?
Reply affidavit,
That he has filed a reply affidavit today. However, same is not on record. Office is directed to place the same and place it on record. List on tomorrow or day after? Tomorrow is what?
Thursday.
Better. Friday. List from 1st September 23.
Oh, please. Review of it.
This matter.
Five.
Counter, Mr. Mayur Reddy.
Yes,
We have the revenue we have filed,
I filed a
the file on behalf of the revenue.
You are appearing for whom, madam? We will means we don't go, learned counsel for respond number 2. Grace fund is granted 4 weeks time to enable her to file counter. Petition is admitted for hearing.
May I submit? In fact, I am in position, that may have to 2 weeks. I purchased it subsequently in the year 2019.
No, no, no.
Allotment was in the,
We have only granted them 4 weeks time. What they do is installments 2 weeks now. Then again it will come up. Then again she will say 2 weeks. So we have at one stretch, we have granted 4 weeks and we have admitted the petition. It will be heard. If you want to file counter, please file.
my counter is being filed today. Correct. The only problem is land has been purchased by
No,
respondent.
no, there is no interim order, right?
There is an interim order.
What? So you have please file a vacate petition, we will consider. Vacate petition.
Like that. Interim order is there. Lordship's interim order is intact.
Intact, no? Of course intact.
Yes, I'm sorry.
If you don't say anything, it will remains intact till he files an application for
Yes.
seeking vacation.
Because only
Please file. We'll consider.
deeply obliged.
I'm representing for respond number 1 to 5, Your Lordship.
Who said that I have to vacate? I don't know.
Additional counter affidavit is filed by respond number 1 to 5, Your Lordship. Earlier, Your Lordship, counter is filed and Your Lordship directed us to file an additional counter. What measures we have taken to prevent the lumps?
When?
Law petition, Your Lordship, on 2nd August, Your Lordship directed us.
Additional affidavit.
We have already filed, Your Lordship.
When, madam?
28, Your Lordship. 28/8.
Some order we had passed, no? Where is that order, madam? Order sheet not there. Control and prevention.
Lumpy skin disease of regard to the animals, Your Lordship.
So which are these 2,117 institutions? Para 4.
Fourth para.
Awareness program where organized.
surveillance engaging the
In
services.
compliance of the order dated, right, madam, in compliance of the order dated 1/8/2023, the respondents have filed an additional affidavit on 28/8/2023. In the additional affidavit, it is stated that that goat pox, GOAT, POX vaccine has already been administered to 30,96,433 cattle by the end of January 2023, and again a vaccination drive has been initiated from 1st of August 2023, and a total 5,25,049 vaccinations have been administered. Full stop. District wise, they should give.
Even on the same complaint, the Lokayukt also closed the complaint, your lordship, that we
District
have.
wise, you should give us details.
Yes, your lordship. The details are,
The
Page
the petitioner, the respondents have for the paragraph subpara. The respondents have further stated in the additional affidavit that 2,117 institutions have been involved for prompt detection of new cases of LSD in animals. Full stop. It is further submitted that awareness programs are also being organized on the general sanitation and biosecurity measure in each and every farmers meeting. However, the respondents have not disclosed the figures or district wise figures of
that was, your lordship, the same complainant filed a complaint before the Lokayukt, your lordship.
district wise we want
That was filed at page number 8, your lordship.
8.
Lokayukt order is on page 7, your lordship. Periodical reports were given.
Sunita, these are
Yes, sir.
camps what we have held.
Yes, sir.
What we are asking is these 2117 institutions.
Yes, sir.
We want district wise list.
That will provide, your lordship.
It is what my lord says.
Huh?
We can cut
Ah.
the district wise.
So like, and this thing,
These are
vaccination district wise
That district back.
there. The however, the respondents have not given the have not disclosed the details of 2,117 institutions which have been engaged for prompt detection of new cases of LSD district wise. Let an additional affidavit in this regard be filed, including the measures taken, latest measures taken up to the date of filing of the affidavit, be placed on record by filing an affidavit within a period of 8 weeks.
Much obliged.
List thereof. Yes. Yes. Huh?
It's both matters.
Fixing a date.
61, 61, 62 both.
Old matters.
Common issue.
Huh?
Arising out of the same, the secretary.
No. What did you say? Old matters.
No.
Huh?
But common issue with regard to same essay arising out of. So,
What have you challenged in this?
well, did this IA order by the DRT, rejecting my application to send the documents. Promisor note guarantee, I will post, etc. Contention and application was filed
No.
for the DRT along with the application, which was rejected.
You wanted the documents to be sent to?
FSL, Government Forensic Laboratory, for examination. Because contention is that she executed a document with regard to registered mortgage, but guarantee concern she has not stood as a guarantor. She has not executed
You have executed a mortgage deed,
mortgage deed.
but not a deed of guarantee.
Guarantee. And the mortgage deed also, in fact, there is some contention raised only for the 5 crores. They have increased to 32 crores. That's etc. That will be bleeding in the essay.
Why are you resisting this prayer? Are you?
I'm appearing for the bank.
Are you resisting this prayer? You are all like instrumentality of state, you have been constituted for benefit of public, right?
That may not, my lord.
No. Are you opposing this sort of an innocuous prayer that it should be deed of guarantee should be referred for forensic science?
Lord, my submission is that it may not be required. That's, the lordship may kindly hear me for.
No, but she petitioner is not admitting. You are not relying on deed of guarantee, therefore it is not required.
My lord, we are only relying upon deed of mortgage. The security,
Correct.
But if they're not relying on the promise of guarantees, your lordship has said on. I'll say, I've asked for the following documents. I asked for the documents, your lordship may kindly see.
Which document? Page
Page 31.
30. Where are the documents? No, not
These
no,
documents to be referred.
30. Page
31, 31.
Where are 30? No list is given 31.
31, below, 30.
Para 4, 5, 6, 7.
I'm sorry, I think your lordship have taken item 61, 62, your lordship.
No. So obviously we will take 61 only because 61 has been called.
I'm sorry, but 62, 62 is not.
No. So what 61 you are not pressing?
I'll just tell about
Then
60,
what is?
62, the order is there. 62, 62, your lordship. I'm sorry.
second.
Page 31, your lordship. Affidavit starts at page 26. 31 is the documents to be called.
This everything you are saying. Like no, very all no.
To be compared,
Lighter vein we are saying all the borrower should take feel inspired from you, execute the documents, avail of loan, don't repay, and then say all cases say that forensic science the bank is a fraud, it does not exist, and I have not taken loan. Obviously you have never taken loan. The question of repayment does not arise.
she is not the company has taken loan.
Mr. One thing, the order is passed by the DRT. Under which provision?
But DRT has got a provision.
Which provision?
Section 22 of the Milord DRT.
So appeal lies under section 20.
But at the time, because the presiding officer was not there, we filed written appeal. But it is
Now the presiding officer is there.
When it's something to what they say, Milord, they
Satyavati Tandon and this thing, it's binding 3-judge bench. Consistent view, Mr. You
Yes,
know.
Lordship, right. I have said in
For a senior counsel, you have a duty to be fair to the court. Every case we are taking the view that Satyavati Tandon file. If there is an interim order, we will protect you till you file an appeal. That will continue till you file an appeal before debt recovery appellate tribunal. Which is the interim order? No interim.
Subject to what they say, Milord, my only submission that your Lordship, not the matter for reconsideration. The bill is not properly done.
No.
Subject to it. If they agree, your Lordship asks.
My submission is this. They are not disputing their signature on the memorandum of deposit of title deed.
No, Mr. We are not entering into merits of the case.
Then minutes. Stay that has been granted.
They are not agreeing. So 26/6/19 order will continue for 8 weeks. You file an appeal before debt recovery appellate tribunal. We will direct the appellate tribunal to decide the appeal on merits.
I have a kind submission to this.
No submission. This order is subject to challenge in Supreme
The
Court.
stay is not on surface proceedings, Millets. The stay is on the proceedings in the essay, Millets. There is no stay with respect to surface proceedings.
Whatever is the interim order shall continue.
Very well.
And in any case, you have a right to file 136 article SLP.
Millets, I have not intended to challenge.
No, you should file, no? How will bank generate litigation for you? They should know. They have to be kind enough to you to generate litigation. You will go to Supreme Court, argue there. That High Court grossly erred in following Satyavati Tandon law laid down by your lordships. That should be the ground of special leave petition. That High Court grossly erred in following the law laid down by 3-judge bench of Honorable Supreme Court. What, Mr. 61, there is no order, interim order, is there any?
Also, there is an order.
All right, whatever, yes.
The orders will be filed.
Yes, fine. This mark the presence with consent of the parties. Matter is heard finally. In this writ petition, the petitioner inter alia has assailed the validity of the order dated 17/12/2019. Mr. This is passed under 14 of surface.
14, section
Huh?
14. The other is under.
Passed under section 14 of the Surface Act. Right, whole thing, 2019. Where is that order, brother? That we had this thing. Honorable
27/12/2019, will not be 19.
dated 27/12/2019, passed by the Chief Metropolitan Magistrate under section 14 of Surface whole thing. Act.
Chief Metropolitan.
Admittedly against the aforesaid order. No, this is appeal. Admittedly against the aforesaid order passed under section 14 of the Act, an appeal lies before the Debt Recovery Appellate Tribunal. The
Debt recovery tribunal.
Debt Recovery Tribunal. What is it, the judgment?
Satchavati
We have
Just
This is 17.
this I have, but we had that order, no? No, Satyavati Tandon you have, but against an order passed under 14, an appeal lies under section 19, Sham Sundar. Full stop. Admittedly against the aforesaid, 1 minute, but don't write. What have you written? Debt Recovery Tribunal under section 17 of the Act, in view of law laid down by Honorable Supreme Court in Bajrang Sham Sundar Agarwal versus Central Bank of India and another, 2019 within bracket 9 SCC 94. Paragraph.
Section.
The next para on this thing, para 5. Honorable Supreme Court in Satyavati Tandon has deprecated the practice of High Court in entertaining the writ petition despite of this paragraph, madam. Paragraph 5 from WP number 20342 of 2023. This thing. Paragraph. In view of aforesaid enunciation of law, we are not inclined to entertain the writ petition. Since a bench of this court, while entertaining the writ petition, had granted an ad interim order on 2/1/2020, it is directed that the same shall continue for a period of 8 weeks. However, liberty is reserved to the petitioner to take recourse to the remedy provided to him under section 17 of the Act. Line below, with the aforesaid liberty, the petition is disposed of. What?
This is challenging criminal MP that has become infractious because I have to file a fresh. The warrant has already expired long ago. Now I have to file a fresh criminal petition under section 14 notes, so that order may not be required in this writ petition. The other matter minutes where they are.
If it is infractions, your lordship assist.
Delete.
Bank has reported. Respondent has reported.
Delete. This petition has been in this petition. What have you? Please read, madam. Next case, madam. WP number 19376.
19376.
In this writ petition, comma, the petitioner has assailed the validity of the order dated 20th August 2019 passed by the Debt Recovery Tribunal under section 17,
Under section 22 of the DRT Act.
under section 22 of the
DRT Act
DRT Act 19, under
1993.
section 22 of the Recovery of Debts and Bankruptcy Act 1993.
Yes.
Full stop. Admittedly against the aforesaid order, an appeal lies under section 20. Under section,
DRT also.
under section 20 of the Act before the Debt Recovery Appellate Tribunal. Right, madam? Then para 5 of that judgment we told, paragraph. However, a bench of this court, while entertaining the writ petition, had granted an interim order on
26/9/2019.
26/9/2019. The same, the aforesaid interim order shall remain in force
67, sir.
for a period of 8 weeks. The petitioner is granted, however, the petitioner is granted the liberty to file an appeal under section 20 of the Act before the Debt Recovery.
Section 18 of Surpass Act, subject to correction. Will it happen?
You said 93 Act and then you are saying that.
Right? Will it, the powers of procedure will not follow. Under the Surpass Act, section 18 of Surpass Act.
Section 20 also 93 Act provides for an appeal.
That is well under an application under section 7,
All right.
19 of that act.
What have you written, madam? Read again. No,
1/8.
wrong.
I think they will not also dispute.
Beginning. No, before that.
Section
20. Appeal lies under section 20 of so and so Act.
In this petition, the petitioner has successfully
Under section 22, no.
Order is passed.
No, read again.
Order is under section 20 of DRT Act. But the appeal lies under section 18 of the Surface Act to the appellate tribunal.
Admittedly against under section 18 of the SARFAESI Act 2002. Then this is the only correction. Before the Debt Recovery Appellate Tribunal.
No, I-
Debt Recovery Appellate Tribunal. No, not Satyavati Tandon, this order. Madam, order passed in WP number 2034 of 23. This is not Satyavati Tandon. This is our order, para 5. In view of paragraph, in view of aforesaid enunciation of law, after quoting para 5. In view of aforesaid enunciation of law, we are not inclined to entertain the writ petition. However, a bench of this court, the bench of this court
27/9, 27/9.
On 27/9/2019
Yes.
had entertained the petition and had granted an interim order. Full stop. Therefore, it is directed that, however, full stop. The petitioner is granted the liberty to file an appeal before the Debt Recovery Appellate Tribunal within a period of 6 weeks from today. Needless to state that the interim order granted by a bench of this court shall continue till for a period of 6 weeks from today to enable the petitioner to file the appeal. It is made clear that this court has not expressed any opinion on merits of the case. With the aforesaid liberty, the petition.
Plus.
What?
I have to make representation. You are not slated. You will not plan the price to.
Representation?
Because with regard to our payment. Once we are only saying.
There are.
To give 2 days. But
No, they will. No, because
it is their interest.
I
know, but.
because then what happens that in case they don't fight,
Yeah.
then they will file extension and all that. Or, you know. Yes.
Plus. Wait, please. The
NCC candidate, some we have done, no?
My lords have modified the order at their request.
Modified the order.
Yes.
Lordship modified the order.
Originally, my lord, the direction was
It
that.
has been modified.
Yes, originally the direction.
Now it have, why it has come?
He made a request, my lord.
I made a request because the admissions are coming up.
Ah,
But he claims what he.
no, correct, Mr. So which modification, where is that order? Please tell us. It has already been modified
Yes, my lord. At his request.
in this petition.
Yes, my lord.
Then
The order, Lordship is not, I did not take the copy. 23/8/2023 order.
Yes, my lord.
23/8/2023.
They said as and when the counseling is happening, their cases will be considered.
The interim order insofar as it directs admission into first MBBS course is modified. However, petitioner shall be at liberty to approach this court with regard to grievance of medical admission and as when date of counseling NCC seat is notified.
On his side,
Lordship kindly say second phase of counseling, they are going to consider all the cases. That if he produced a certificate was, no.
So this has to be heard according to you.
yes,
It has to be heard.
Have you filed counter?
Will be filed counter. And vacate also. To file counter as well as vacate.
Then.
the submission was, my lord, they are not going to undertake. Now, my lord, they say they are undertaking, but I am ready, my lord, subject to my lord's convenience. I am ready to argue the
When
matter.
Mr. Rao,
With respect to the state, we have filed a formal.
you are there, why? See, additional advocate.
General is already on behalf of university, my lord.
No,
And
you are not appearing.
My lord,
You are appearing for a state, he is appearing for university like this.
Blood is playing in Lord a writ of mandamus, directing the state to let the incorporate the reservation.
That can't be done.
That's the
That's the
university.
relief, Lordship.
No.
That's my kindly see the relief.
But the rule is under challenge. The state has to sustain, my lord, the challenge. The university has no say in the matter.
1 minute. When are you starting? As an officer of the court,
Yes,
he
yes,
can address.
right.
We
Yes.
can appoint him a Michael's
Yes, my lord,
officer.
yes.
So, Mr. Rao, when the second round of counseling is starting?
But day after tomorrow or later. NCC. The date is not yet fixed.
So there,
3-4 days, notification will be issued. 1-2 days.
Wednesday. Tomorrow you will have that. So, with that.
No, tomorrow we'll have floodgates open for the individual admission.
No. This is focus. Nothing else. Don't. There will be fresh masses. So here tomorrow. Petition list tomorrow. Tomorrow we will hear.
Tomorrow.
Give a synopsis.
Yes, my lord, and in fact, I am ready.
Conclude within.
May I make a request? Tomorrow and day after, my lord, I have personal inconvenience. My lord, any other day other than tomorrow day after, I am extremely sorry. My lord, today I am ready. I can only request.
That, Mr. Don't then this thing then say that it is being done and admission.
No,
You
my
are
lord,
seeking an adjournment. We are ready to.
I am not saying I am ready.
This is Mr.
Yes, my
This is taking into account the real possibility of your case being taken up, right?
lord. Yes, my lord, I understand.
That's why we said tomorrow, because tomorrow we have so far 54 cases only. So we thought that we will take up your case.
Very well.
Now you want it on Friday, the bench is till 1:30.
Tomorrow, your lordship proceed to.
Please appreciate us.
Yes,
For
Lord.
the interest of these students, we are not getting admission in his university.
My lord, it's all their own doing, my lord. I'll demonstrate. I'll demonstrate
No, no.
tomorrow.
That
Yes.
the only request to use, Mr. Counsel, please prepare a synopsis, be brief.
I will.
It's not like review of Keshwanand Bharti.
No, my lord, it is not. I have already prepared.
Prepare a synopsis and this thing we will hear Mr. Rao what additional AG has to say. I don't think he has much to say when Mr. Rao is arguing.
Meanwhile,
In this matter, my lord, the counter from third respondent is required, my lord. I think, my lord, I
I received my lord parallel cannot, just 2 days, my lord, I will get it, my lord. Yes.
We are taking it up tomorrow, Mr. Kumar.
Tomorrow, my lord, I'll try to get it, but the draft on.
Please get it.
now, central government recommended us.
Mister, we will be the happiest person to fix it on Friday and sit till 1:30 and say number not reached, and then it goes for Monday. We no. Why we are insisting? We have told him that argue tomorrow despite his inconvenience, because we want to decide it genuinely.
Yes.
Otherwise, we will give a date where we have already fixed 82 cases, 6-9. It will never reach.
Yes.
We will be happy.
At his request, my lord, your lordship granted time on the last occasion and no contract.
Tomorrow, I'll get it duly signed, my lord, but otherwise the draft contract is ready.
The only thing is day after tomorrow is Friday, Mister. Friday, no?
No,
Say.
Today is Tuesday.
Thursday is
30th, 31st, maybe.
31st.
My lord, my nephew is getting married on 31st. I'm extremely sorry, my lord, I cannot attend. My lord. That's why I said, my lord, tomorrow and day after.
But otherwise, lordship, tomorrow I'll get in synopsis, my lord, so that lordship can, draft counter on this, my lord, I'll synopsis, my
Hardly you have hardly anything to do. You can support Mr. Rao.
lord.
Huh?
Tomorrow I'll get it.
You are supporting Mr. Rao.
My lord.
It is they who have changed the policy of reservation, my lord.
You are appearing Mr. Rao in these cases, no?
Government is, government
No, but you also appear.
I'm also.
Please appear. We will appoint you a amicus.
University is a party earlier.
University is a party.
Yes, yes.
My second respect.
So we will hear you, Mr. Rao, in these cases before whatever additional AG has to say. We will hear you, and if you are not there, we will appoint you as amicus. Say that you are not party.
I'm a party, my lord, I will appear. My lord, the Advocate General also, my lord, I will appear, my lord.
No, he is appearing additional advocate.
Yes, lord. But the
Advocate General will appear.
I am an additional advocate, I am myself.
No, you will argue, right?
Yes.
Not Advocate General, he is.
yes,
But we will hear you also. You are the one who has defended, government didn't argue the bunch today. We have delivered the judgment. That's why he has taken on everybody single-handedly, and most of his submissions have been accepted except rule virus.
but I failed, my lord.
Not failed. Mr. Rao succeeded. Interpretation of rule, none of the petitioners fall under that capacity, this thing, this category. This you have succeeded. You have said that full bench of the court has interpreted the rule. We have held, yes, full bench interpretation is of great help to us in interpreting the rule. All submissions, if you read, we have accepted. List on who prays for adjournment? Mr. Praveen Kumar undertakes to produce a synopsis
Tomorrow,
on or before next date of hearing. List on 31st August 23.
My lord, 31st, my lord,
Oh,
I'm sorry, marriage.
30th August.
Yes.
30th August.
Yes, yes.
Oh,
I'm sorry, my lord.
tomorrow.
Yes.
Tomorrow. Sorry, I didn't realize.
Next items.
So 63 to 66, everything. Please supply, Mr.
అది అవి ఆ కేసుల్లో ఇందులో రాలేదు. పోదామా?
Item 16, pertaining to contract qualification.
67 to validity of rule challenge. Validity of rule is under challenge, right?
Yes. But in fact, this matter was carried to Honorable Supreme Court, my lord, in 2018, and we have filed an expedite petition in 2018 itself, my lord, for advance hearing. Because the rule was under challenge, and several of the petitioners, my lord, were not allowed to participate in the recruitment process because they were made ineligible by virtue of the rules.
No. What are you saying? that the matter is pending before Supreme Court?
No, my lord. We have approached the Honorable Supreme Court, my lord, directed us to make a request here. In view of the request, we have filed an IA here, my lord, for expediting the hearing of this.
Where is the order of Supreme Court?
Right, it's filed in writ petition number 1353.
Where is the order, Mr.? When that order was passed by Honorable Supreme Court? When?
18. We filed an IA in 2018 only.
What were you doing till 23? I have only joined 5 weeks
So, my lord,
back.
it was always getting listed, my lord, but because of the probably city of time and administrative reasons, my lord, it was not being heard. Well, we filed an IA in 2018 itself seeking for expedite hearing. It was getting listed, my lord,
No,
but
no,
it was only
this-
that couldn't be heard because of paucity of time. But now what has happened, my lord, the
The
state has
issue with
now,
regard to validity. So it will be heard.
now what has happened, my lord, the state has issued a new notification. They are coming up with a new notification relying on the same rules. Again, it will be the same problem. So there is a little bit of urgency, as your lordships may kindly be taking that into consideration.
In this batch of rate petition, validity of rule 4 within bracket Roman capital 2 within bracket small Roman 2 of what rules?
Teacher recruitment test rules.
Of which is the name of the rule? You don't know.
The teacher recruitment test rules. GMS number 25.
The Telangana Direct Recruitment for the Post of Teachers Rules 2017. That's correct that you did not even knew the name of the rules. So you should have read it from. When we write in the order sheet, it has some sanctity, mister. We cannot write teacher recruitment rule like you. The Telangana Direct Recruitment for the Post of Teacher Rules 2017, right? Full stop. No, how many this thing? So any of the petitioners have secured? So those people go out, right? They are selected. No. Arey, mister, you didn't get it right. We didn't ask you who is selected. We told you which of the petitioners have secured minimum cutoff marks in each of the category. What? Give the names.
My friend has given, my clients have secured more than minimum marks.
All right. Which your client means which
WP
case?
number 9164
Then,
of
Madam, write in
2019.
compliance of the order dated 10/4/2023. The Telangana State Public Service Commission has produced a statement indicating minimum cutoff marks in each of the category. Full stop. Will you give a joint statement like
Yes,
both
petitioners in one writ petition who have secured more, who have, so. No, in this entire 26, there is not.
These petitions go, right? The details of the petitioners are as the details of the writ petitions are as follows. Quote 26, right? Paragraph. In view of aforesaid subsequent event, comma, the said writ petitions are disposed of.
My lord,
Writ petitions number so and so are disposed.
but they have only given us the document. I'll just narrate, my lord. Serial number 3, 43633.
Ah.
This is matter pertaining to physical education teachers. Cutoff marks do not have any
Then why have you got yourself in bunch?
I'm sorry.
Why did you get yourself in the bunch? Then it has no relevance then.
No, my lord. Now, by saying that we are not having the cutoff mark, that will not have the
Alright, so
relevance.
madam, in the bunch you write WP 43633/2017 be de-linked from the bunch and be listed separately for admission. Right.
My lord,
So 1 minute. Then other cases,
Lord,
following petitioners 1, 2, 3 delete, his case has been de-linked. Remaining cases 4 to 26, right? Huh?
I'm extremely
These
sorry.
writ petitions.
I'm extremely sorry. In matters, my lord, what has happened? I'll just narrate 2 minutes.
No, you are appearing in all the cases.
Yes, my lord. Around 22 matters are in my name.
So
I
then
may-
he says, what, 1 minute. Supposing if he makes a statement that the petitioners have not got the cutoff marks, right? So what is the effect on the challenge? Is he correct in saying that those petitioners lose locus to continue the petition? Correct or not legally? Then we will see.
My lord, I may only permit it, my lord. 2 aspects, my lord. They have given the papers just some time back. They said there are many not.
1 minute, mister. What we are trying to understand, is he correct in saying that the candidates who have secured marks below the cutoff marks are not entitled to further prosecute the petition? Is he correct in saying so or not?
Maybe, yes, my lord.
Correct.
Insofar as the other writ petitions, there are
Correct.
few petitioners who have secured more marks.
That those he has separate, those will survive.
That in the list which is placed before your lordships is mixed with
Which
all the
case?
writ petitions.
No, he is saying it is signed by assistant secretary. He will be hauled up for contempt, misleading the court. Please understand, it is duly signed by the assistant secretary stamp. Are you disputing this?
Yes, my lord.
Huh?
My lord, I'll just say 43768.
Ah. 4-3.
In 43633 and 1111.
No, one,
Well, there is this-
double one. We have double.
My lord, there's physical education teacher matters
Ah.
where minimum cutoff mark is not the criteria. It's
So
sports
we will
certificate.
de-link it, Mister. We will de-link these two cases.
And
What about the remaining two matters in this list?
in other batch of matters, my lord, the Honorable High Court, my lord, did not permit them to write the exam. What the Honorable Court did, my lord, is since I am not permitting you, selection and appointment.
What you are up to creating some confusion, right? Because
Well,
we are
that's
about
why I
to
was-
get up. We will continue. We thought that we were sitting so that we continue, finish it before 1:30 only. You are not permitting it to happen. So don't think that we will not be able to find out. We are coming back. We taken up at 2:30. And don't make incorrect statements.
Let them verify now with the list which are the matters which are not covered, so that.
So you can verify now what are the matters which are not covered during the break and tell us that, Mister, you should be fair. I mean, duty, as I've been telling, we have been telling everybody, as officers of the court, you owe a duty to the court to be fair at all times. You will not get job in this, right? Even if petitions are allowed, you are not going to, you are an advocate of this court, you are an officer. So you are required to conduct the cases with amount of dispassion, right? Right? So therefore you must fairly tell that, sir, these 26 matters, these 2 matters are different, remaining he is correct in saying, or 4 matters are different, remaining 22 do not survive for consideration. This is what we are prepared to do it. We are not in a hurry to get numbers, nothing.
I did not have time to verify. They gave it
You
just
please-
few minutes back.
So you should say so, that I need time to verify. That is also understandable.
I'll get back to your lordships, my lord, immediately by 2:30.
2:30 you will
Yes.
be able to, then we'll continue. If you are able to verify, otherwise, you will verify?
I'll let.
Okay. Two 30. You can smile at least, Mr.
Yes,
Tom. Nothing has been done.
My lord. This matters, my lord.
None of the
I-
cases.
No, my lord, it's not like this, my lord. It's
Huh?
what has happened is several of these petitioners, my lord, who have taken part in the exam, my lord, there are certain
No, no.
vacancies which are left unfilled, which are kept
One minute.
aside. I'm sorry.
These, we are asking you to point out with reference to this. No case has become infructuous.
No, my lord. In my respectful submission, because one, it is
All right, you place it on record instead of passing. Yes,
on 2 counts, my lord.
1 minute. We will hear it, Mr. We thought that you could, we have postponed it only because we thought that you will be able to tell us that these cases have become this thing, but you are not saying all cases. You have said 26, all of them survive.
Even if the writs are allowed also, my lord, they are not zone of consultation.
One. This will be an argument in final hearing.
That's what happening.
He has to seek instructions from 26 petitioners. So you understand, right? 26 petitioner multiplied by 50, how much instructions he will get. So that's why he is not permitting. Just saying that it's all, he knows it. But we don't have this.
My lord, and
Mr. Vidyasagar, what is like the issue involved and can it be concluded in 5-10 minutes? Why to give this young man a long rope? He is anxious. Huh?
In fact, Lord,
So,
I was asked to file a synopsis. Synopsis is filed long back.
sir, can it be done today in a, or otherwise it will go on till 4:30? We don't want to do it 4:30.
Today, I am ready to, but
my lord, Learned Senior is appearing in one matter, my lord.
His case be decided.
Hindi Pandits, my lord, wherein I have a matter relating to the same subject.
Then we are not asking
have,
you, are you ready, not ready?
I am ready, my lord.
How much time will you take?
But if each of the individual cases are to be taken, my lord, I take at least 3 hours. All matters together. My lord, there's 5 subjects which I have to place before your lordship.
No. So 5 subjects, different grounds of challenge, right?
No, my lord.
No.
Rule is
The question of law, the validity of rule remains the same, notwithstanding the fact it's 5 subject or 50 subject or 5,000 subjects.
Yes.
The validity of a rule can be challenged only what grounds, if you can tell us.
But unconstitutional.
What ground it can be challenged, validity?
Unconstitutional, my lord. One of it is
What ground?
Like in our case, my lord, it's
That the rule making authority has no power to frame rules. Second is in violation, it is in this thing, it is violative of fundamental right. Third ground, according to main ground, is that the rule making authority has traveled beyond the scope of authority and has made a rule which was not empowered. So it is these 3 propositions remain well formed, well trenched, irrespective of the case. 50,000 subject, 1 lakh subject, 1 crore subject.
Lord, your lordship may kindly give me one hour time, my lord. I'll try to finish all of the matters. It's all majorly it's on the repugnancy.
This is Mr. 3 grounds. You didn't understand, right? Still.
I agree.
No, you have challenged the validity of the rules.
I am trying to be-
This thing is, the irony is, the court is telling you the grounds.
My lord, I am trying
And
to be
despite that, thereafter you are saying that I will get 1 hour.
No, my lord, I am trying to be
See, I wish we had the facility where at the time when I was practicing, that the court will tell us what to argue. So I would have never crossed this side. The life in our times when we were there was very difficult. Here is that you challenge the rule. The court tells you what ground the rule can be challenged.
I was only trying to be optimistic, my lord, giving shorter time and
Nothing optimistic. No, we will record this. That 3 hours. We don't have that kind
No, my
of
lord.
time.
I'll try.
This thing, Mr.
I'm
Forget about
absolutely
it.
sorry. I'll try to finish it.
No, you give written submissions. See, a senior counsel like him in a bench headed by Justice Ravindran, former judge of Supreme Court of India, who was Chief Justice of our High Court. He asked the council, how much time will you take? He said, I will take 1.5 days. He said, I have never heard this sort of an argument in my entire life and I will never do it. But this is a bunch. You only have case. We will proceed with the bunch. And then you have to give, he told, listen, he told the senior counsel that you give written submissions. And the written submission should reach us. It was Thursday. I was also in that bunch as a young counsel like you. It was a cess on this thing, generation of electricity. Issue pertaining to cess of generation on electricity. And that is a reported judgment. I relied on 72 Supreme Court and he heard me. He said, after all counsels were done, he said, yes, young man, what will you argue? Please do not repeat what they have argued. I said, yes, sir, I will argue. Then he heard me for 20 minutes and I relied on that judgment. Then he told that senior counsel that this by Monday written submissions would reach us, should reach us, your written submission. He said, logistically, it's not possible. I am an outstation counsel. He said, forget about it. So same thing we will do. We will say that forget about these cases because you are arguing 3 hours. This is not Keshwanand Bharti review. Right? Validity of a rule on 3 grounds which the court has just now told you. If you can't fit in your case in any of the 3 grounds, that means you don't have a case.
30 minutes, my lord. 30 minutes, my lord. I'll finish it in 30 minutes. I get your lordship's, my lord. I'll take it in 30 minutes. All the matters. Because my main ground is repugnancy, my lord.
Be in touch with senior counsel, take the benefit of his wisdom. That will always help. Right? Mark the presence in these writ petitions, the petitioner you will take still 30 days to find out whether what is the impact of this. Because 1 hour this rule so and so, got it, rule so and so of the Telangana direct recruitment for post of teachers rules 2017. Full stop. In compliance of the order passed by a bench of this court, learned counsel for Telangana State Public Service Commission has produced
My lord, I'm only seeking your lordship's indulgence, my lord.
No, you have understood. If you have
Yes,
not understood the order, we can't help it.
Yes.
Just now it has been dictated in your presence. Council for Telangana Public Service Commission has said that those persons, we are not repeating. Senior council has made submission. What is your submission?
My lord, my respectful submission is, my lord, the challenge to the rule survives. My lord, in fact, even though petitioners do not possess the cutoff mark, because now the next recruitment, they may not be, again, they will have the same problem. They have already issued a fresh notification, my lord, with the same set of rules. So they will still be continue to be ineligible.
No, no. So what you say that even though the petitioners have secured cutoff marks, below cutoff marks, still the challenge to rule
Challenge to rule
survives.
survives.
So in other words, a statutory provision can be challenged by anyone, even though he may not have locus to challenge. This is the submission.
My submission is, my lord, when he challenged, there is, my lord, when he challenged, he had
Senior
locus,
council.
and he would continue because
Supreme Court judgment on this point, which he may not have read. Something to do with rice mills order, locus
of
certiorari. So in context of writ of certiorari, Supreme Court has said examine the context.
my lord,
However, learned counsel for the petitioners, learned counsel for petitioners in aforesaid 26 writ petitions submit that even though petitioners may not have secured the marks, may have secured the marks below the cutoff marks. However, the challenge to the validity of rule so and so, right, of so and so survives for consideration in the batch of petitions.
may I also, my lord,
Full stop. This is the only submission. We have only recorded this. We are not doing anything. What other submission?
my lord, in writ petition number 1353, my lord, the Honorable Court was pleased to, my lord, not permit the petitioners to write the exam. I'll just read, my lord, if your lordship
No,
permits.
no,
the
so you
interim
want
order-
modification of that order.
No, my lord.
You want a special examination to be held today
No, my lord.
at 5 p.m.
My lord, may I only read the operational portion of the.
What is the purpose?
The Honorable Court, my lord, said that since we are not permitting you and the validity of the challenge to the rules is pending, all the selection and appointment will be subject to outcome of the writ petition. That is the
goes
order.
without saying. If you don't understand this elementary principle,
Well,
we can't help.
My respectful
That
submission,
doesn't
my lord,
need an order. Nobody says that it is not subject to result. He has not argued that it is not subject to, and I will do whatever I want.
my respectful submission is the list of those particular writ petitions contain those writ petition numbers where the Honorable Court has not permitted us to write the exam.
Mister,
Therefore,
we have recorded your submission. We will examine the issue of validity of rules,
very well. That's not concerned.
and we can't give you 3 hours. If you want this, we will record this.
Okay.
No.
I'm sorry, my lord, I don't.
20 minutes, give whatever. Beyond 20 minutes, what you have to say, give it by way of written submission. Nothing. This all, those days of leisure have gone where question of lease and license was argued before the High Court for 2.5 days. You see, we don't have time. If you want a decision, otherwise, rest wherever you want, relax. Petitioners won't get anything. You also know they won't get anything. Relax.
In so far as item 70,
Petition is admitted for hearing.
one
Means, you know, where he has produced the charts, the particulars which read as under this chart in the order.
Let us still
Which chart, Mr.
It was not time permission. Other candidates who are zone of consideration as per cutoff mark, I have separate list. May I place it before?
So then sub paragraph after 14, learn it. This you are not disputing, right? You should dispute this also. That no, I have not secured minimum cutoff marks.
My lord, with great
Lighter vein, Mr. Smile at least.
No, my lord,
We are not doing anything, it's being adjourned, right?
I am in a situation, my lord, where I had three children in the same yard.
We are examining the validity of the rule at your instance, right? So at least you should smile. I just said in the lighter vein that you will not dispute this proposition. You should say, yes, sir, why should I dispute? This is the simple answer. Nothing, mister. Don't take it so seriously. What is this post?
SGT and PET.
Huh?
Teacher and PET.
No,
You are not going to use an officer of the court, right? You will not become PDD or something. Huh? You will remain officer of the court. Argue like a professional, true professional, dispassionate manner. Don't engage, never identify yourself as with your litigants, correct? So learned, after quoting this, Learned Counsel for Telangana Public Service Commission has also placed on record the details of the petitioners who have secured the marks above the cutoff marks
Without qualification.
without qualification.
Yes.
So they are in any case, they survive.
No, after your lordship adjudicating the main case only. According to the validity of G1
Irrespective of this thing, they have secured above cutoff.
cutoff mark, but
So you will consider.
without educational qualification.
Don't know.
This kind of rules.
So petition is admitted for hearing. Yes.
With my Lord's kind permission, my Lord, I am appearing for the NCT respond number 1. And my name may be printed, my Lord.
Office is directed to print the name of Mr.
Mehboob. M. Mehboob Ali in place of K. Ramakant Reddy and Muddu Vijay.
Right. Up to what, which serial number?
Milord, place this, Milord, part of it.
Please place it.
Yes.
We have said placed on
Yes,
record.
Milord.
You have got copies.
Yes, sir, given.
Madam, up to which number?
Milord,
107.
Not sir, may I?
So if you want early hearing, file an application, we will consider.
May I make one request, my lord? In item number 1350, my lord, in that we have filed an IA, my lord, which is for expedite hearing. My lord, the reason why I'm insisting is the
You are, see,
date is already given.
Mr. Counsel, if you want to expedite our hearing, you have to be brief and to the point. Don't, this thing I will take 3 hours. You should have said 30 days.
I sincerely apologize on that.
No, there is no question of apology. Why we are telling you all this? Because you are a young advocate and we thought that we think that prima facie, I am inclined to think that you are amenable to reason. All this because of, not to extract sorry from you, nothing. You should take these constructively.
But the reason, my lord,
Now senior counsel said that I will conclude 10 minutes. The provision remains the same. You should have said that I will adopt his submissions and adds whatever he has not argued, if any. You are saying 3 hours.
the point for consideration with this
Nothing, no point.
different.
No, but validity of rule can be challenged on these 3 grounds in his case also, your case also. It's not that additional 5 grounds in case because he is senior and only 1 ground because you are a junior. Not that. Which case you have filed IA?
Alert item number, writ petition number 1350.
No, it's item you don't have the list.
88, my lord.
Fix an early date.
Yes.
Why? What is the urgency?
Lord, now the state has issued, my lord, notification this month.
Don't show fingers.
I'm sorry.
This is again bad manners. If I show fingers like you, will you like it?
My lord, I gave
No.
papers.
Will you like it if I show? No, don't show fingers for the court. Yes.
That the state, my lord, has issued a notification, my lord, notifying vacancies of 5,000 vacancies in respect of the same post. Again, now, my lord. So there is an urgency because they will follow the same rules. Again, the petitioners will be ineligible for the same post, my lord. There is a...
That cause of action is yet to accrue.
I'm sorry.
Cause of action is yet to accrue. This you are saying it should be heard early to avoid possibility of a future litigation.
This same rules are made.
So you will have to, Mr. It is under challenge. What is the effect if you succeed in the writ petition?
I will be eligible for...
No. Effect. Does it apply prospectively, retrospectively? What is the effect? This is not a coaching class going on for, sorry. Yes. Think about it, what we have said. That if it is struck down,
it would go...
as senior counsel.
It would go from the root, my lord. Goes from the date of its inception. Because we have challenged that it's repugnant to the NCT regulation.
So what is you are only required to tell us in item 71, what is the urgency? When is the notification issued?
My lord, I have given, my lord, it's in the month of August. This month only, my lord, on 20.
No, you don't know, right? We are asking you, you are an officer of the court. You are here to assist us.
Lord, it was given on 25th of August 2023.
No, what is the averments of early hearing application? Why do you want simple question?
Lord, early
Another
hearing-
notification 25/8/23 issued. 5,000 posts will be filled up. So you will not qualify. What is the submission?
My lord, my respectful submission is, my lord, when the IA was filed in 2018 also, my lord, we were not permitted to write the exam. But now, during the pendency, now the state has issued a fresh notification for the same post, but same rules again being applied, which are challenged before your lordships. My lord, therefore, my lord, I am requesting your lordships to have a, my lord, early hearing in respect of the challenge to the rules, so that these people can be continuously eligible, because otherwise they'll still continue to be ineligible because the rules are, my lord, not allowing them to participate in the recruitment process.
What is the age of eligibility? Like age?
Right.
Forever life till. What is your age?
But I am 41.
No, not your candidates. Candidates.
Petitioners are very well within the age, but all of them.
That's the question, not your age.
All of them
We are not
very well-
ascertaining whether you are fit for elevation. You are telling us the age, not this thing. We are asking, there is rules prescribe some eligibility criteria. What is the age of qualification?
Age, my lord, maximum age is 49.
49 years.
Maximum age is 49.
And you are well below 49. All. You are also like 41. You are also eligible under rules. So you want early hearing.
I may please.
No, but what happens 3 hours? We can't give.
My lord, I would not, my lord, in my respectful submission, my lord, I
We will hear.
apologize for that.
Senior counsel has got a first right of audience being his designated. Thereafter, you will argue only on the grounds not covered by him and give a written synopsis. Correct? Is that clear?
Very well. Very well. Because, my lord, I'll make my submissions as precise as possible.
No. He will argue first. You will argue on the grounds, legal grounds not covered by him. Right? In 20 minutes. No.
My lord, I don't know, my lord, grounds of challenge raised by the senior.
You will hear him.
Very well.
Grounds are only 3, mister.
Very well.
No. What are the grounds of challenge to rules? Any rule for that matter. Forget. What are the rules?
Your lordships have already expressed.
No, tell us. We want to hear. He said, you don't know what are the grounds, so we are asking you. What are the grounds on which rule can be challenged? Any legislation can be challenged. What are the 3 primary grounds?
That's in violation of fundamental rights, my lord. It's a first ground unconstitutional. My lord, also where the state is denuded of power, my lord, and exercising over and above. That in, like central enactment or anything, my lord, it's repugnant. In this case, my lord, we are saying that it's in repugnance to the central enactment.
It can spill over. Yes.
Teacher with teacher with
Age. Without me, teachers.
71. Heard on IA number 1 of 2019. Clarity of mind, nothing is this thing. Clarity of mind. 1, 2, 3. These are grounds of challenge. Elaborate. Nothing.
Some of the books we have been, 11th we have given teachers funds. 14th we have given going after. 14th we have given the such as schooling. Which have. Then we have given electricity batch. Electricity batch also we have given. Some data. I do not know. That matter.
Vaidyanathan's case was.
Yes, Vaidyanathan. Santosh, when did we give the date for that, Mr. Vaidyanathan's matter, electricity matter?
I'm not aware, your lordship. I'll find out. I'll find out.
Find out and tell us so that we keep a list as to.
Otherwise
I'll just
I'm fixing the date and in the end. All right.
Just find out and tell the court officer.
I'll-
100. Yes.
You can have a list of
Yes,
dates, important dates, not to have. Doesn't miss out.
Yes.
Yes.
May it please your lordships. These batch of matters, my lords, they deal with, some of them are public interest writ petitions. They relate to rehabilitation of women for sex trafficking, children in
This is
conflict.
for admission. We will admit it. It
Yes.
requires.
Formally
yes.
admit, but your
Mark
lordships
the
last time
Ah.
had wanted, there's an order in fact by the division bench requiring both the amicus and me to give a small note.
Where is that? Which
That
order?
note, my side is a little inadequate, my lord, so I'll file it at the next hearing.
All right.
Mr. The amicus as the
What
dictum
date?
is ready,
What date?
any day.
No. Which date that order saying that?
This is long ago, my lord, sometime in 2021.
21.
28/7/2021.
28/7.
28/7/2021.
I can pass on a copy of law.
So.
It's at the end of the order, my lord. It's a long order. Page 1.
Status report, this State Legal Services Authority was required to file a status
State
report.
has filed its status report.
No, this Legal Services Authority is also directed to file.
You know, TSLSA, Malad, has filed later after this order. But in fact, Malad, that is not in conformity with the earlier orders which have been referred to. Malad, I'll point out whenever the matter is being taken.
All. Mark the presence of everyone. Petitions are admitted for hearing. Yes.
Lordships are fixing a date, man.
Please file some application. We will fix a date.
Much of it.
Yes. 112, madam.
Your lordships, may it please as your lordships, your lordships, it's,
What is the issue?
your lordships, it's regarding non-implementation of section 12(1)(c) of right of children for free and compulsory education, your lordships. We have filed expedite petition, your lordships. During last hearing, your lordships, counsel for respondents informed this honorable court that there is a batch, your lordships. However, there is no batch listed, your lordships.
You are party in person.
No, your lordships.
You are an advocate.
Yes, your lordships.
All right.
Your lordships, earlier, your lordships petitioner herein filed one PIL, your lordships. However, during bifurcation, your lordship, the file has been transferred to.
What's your name, madam? What's your name?
Manasa, your lordships.
Okay, so it mentions Sri Lekha Pujari party in person. So that's why we thought, are you?
Three matters are there, your lordship. Three matters are there, your lordship.
Matters are there, your lordships.
So what, yes, madam, we will admit it.
Counter is filed.
Your lordships, all the pleadings have been completed, your lordships.
No,
There
there
is
is-
an urgency, your lordships.
Madam, this is a public interest litigation.
Yes, your lordships.
If you don't behave like an officer of the court, we can, Sheila Barse, please read, what is your locus? Hmm? This is just like saying that the state is directed to ensure that provisions of CRPC and IPC are followed. All laws are followed by the state. What is implementation of 12(1)(c)? Now tell us, what are the figures in respect of state of Telangana? Where are the figures that children have been deprived of their fundamental
Your
right
lordships.
and or the right guaranteed under 12(1)(c)? What are the figures, madam? Tell us.
Your lordships,
This is a vague prayer.
yes, your lordships, as per the.
No. Where is the statement showing that these people, in respect of these children, 12(1)(c) has not been implemented, therefore petitioner is filing this petition pro bono to seeking implementation.
Your
This is
lordships.
just like seeking a direction to the state to follow provisions of CRPC.
No, your lordships, as per the section 12(1)(c) of right of.
Not 12(1)(c). What we are asking is, in order to file a public interest litigation, you are saying it is not being implemented in all private schools. What is the material you have placed on record to show, got this material to show that this is the information, these are number of private schools are there. In no school, this 25% rule is being implemented. This is the, I have caused some verification. These are the things which are required for maintaining the pill.
Where are the private schools in the writ petition
We
who
have.
are not giving admissions? Just like madam.
Your lordships, may I make one
Just
submission,
like
your
making
lordships.
a driving inquiry, madam, the bill that is filed like more like a making a rowing inquiry without even bringing on record. I have asked for this information. Let us say in Hyderabad there are 1,400 schools.
Your lordships,
So out of 1,400 private schools, how many schools are issuing, complying with this 25% condition? How many schools are not following? And what is the basis for that?
your lordships.
Can if you are not a party to the petition, can an order be passed against you?
No, your lordships, may I
No,
make
no.
one submission, your lordships. Your
Madam,
lordships,
if you don't understand, fine. If you are not unable to understand what is told by my brother, fine.
your lordships, we have filed
We
RTA
will have to
application,
appoint-
so your lordships.
We will
Your
appoint
kindly.
somebody as a amicus curiae. You are
Your lordship.
countryman.
Your lordship,
It is
may I
a
make one
publicity interest
submission, your
litigation.
lordships.
Publicity interest litigation, right?
No, your lordships, may I make one submission, your lordships. Petitioner herein filed WPPIL, your lordships, LDR, your lordships. Your lordship, there is an order, your lordships, kindly, number 54 to 61, your lordships.
This is not the answer to the query post, madam.
What my lords have asked, did you understand?
Your lordships, as per the law, your lordships are, as per the act, your lordships, state government need
What
to
is-
issue notification, your lordships.
Which is your petition? First tell us. Because these are 4 petitions. You are every,
WPPIL number 38 of 2021, 20,
only one case you are appearing.
yes, your lordships.
Give 38. Then don't make a representation as if you are appearing in all 4 cases. What is the prayer in the 2 things you answer, madam? If you understand, well and good. Don't understand, orders will follow. You have, listen to us carefully. You have prayed for
I have prayed
1 minute.
your lordships implement.
You have prayed for implementation of section 12C
Yes, your
of RTE Act. What is the material pleaded in the petition or placed before this court to show, number 1, that in respect of who are the educational institutions which are violating the right under 12(1)(c. Number 2, where are those educational institutions? The respondents are only 4 in number in your petition. So Third question is whether in the absence of educational institution, whether any effective relief can be granted in a public interest litigation. Answer that. We will come to urgency after you answer.
Your Lordships.
What is the data?
Your Lordships, we have filed RTI application, Your Lordships, in page number 99 to 102, Your Lordships.
There is no data, madam. All right.
103, Your Lordships.
What can we get? In a public interest litigation, no roving inquiry can be made. Thank you. This is all.
Your Lordships.
Yes. Anything else?
Your Lordships.
You are answering the question.
We have.
Once my brother has asked, once I have asked, you are not answering the query.
Your Lordship.
What is the data to show Mr. Prasad, young person, not able to comprehend the scope of questions? So she has 1 minute. Please explain to her. The communication will be faster. Here it is what is that we are enemies, so she will never understand. We are asking her 2 questions. Mr. Prasad, this is a public interest litigation in which petitioner seeks implementation of section 12(1)(c) of RTE Act 2009. So first question we have asked is, what is the data particular petitioner has to plead to show that in respect of a definite section of people, this 12(1)(c) has been not been implemented, violated. There is no data. She is unable to tell the data, trying to buy time and doing whatever. You have seen her. Second query is, which are the educational institutions who are violating 12(1)(c)? Those you see petition cost title, only 4 respondents. 1, 2, 3, 4. So in the absence of those educational institutions, can we grant any relief in public interest litigation? Third thing is, in a public interest litigation, no roving inquiry can be made. The petitioner is under an obligation to conduct an inquiry and furnish facts and not be involved in a blame game that they are not doing it. It is not an front to fight against the authorities, which she is trying to do. She doesn't seem to understand our queries. Please explain to her in your own way so she understands, and otherwise we pass a note saying that this can't be entertained. That's what Mr. Prasad, we have told.
Mr. Harendra Prasad. In fact, what the petitioner is required to do is at least make some inquiry on her own. Maybe you see in 1400 schools in Hyderabad, she may not be able to collect that information. Some schools she has to make an effort, bring that material on record and also approach the authorities saying, I have caused an inquiry into these things. This is how they are flouting the rule or the provision. That is why I am giving a complaint, and if it is not done, then approach the court.
I was indicating to.
No, and Mr. One thing, and those, nobody is there.
Yes, nobody.
How roving inquiry can be made?
I was indicating, my lord.
Tell her, please, so that she understands from you. In the fond hope that she understands what you say. Not successful.
I'll seek time, I request time, your lordships.
Then you said urgent, right? Right now, urgency.
Lordships.
2020, you
Make them part.
have filed the petition, forgot about it. 3 academic years are over. Whom do you tell, madam? Think. You have to properly study the subject. Make available this thing, particulars on which you are claiming relief. Implead those persons as parties.
Yes, your lord.
How can just like publicity interest? That's why Supreme Court says publicity interest litigation. And all youngsters appear in PIL. correct? In this public interest litigation, petitioner has prayed for the following relief quote 1 and 2. However, however, when a query was put to learned counsel for the petitioner to substantiate by the material, the reliefs as prayed for by the
May I please, your lordships?
yes, Mr. Oh, back from Supreme Court, right?
My lord.
Mr. Rao. Arey, lighter vein. It's good to see you smiling. Huh? Lighter vein. You see, on remand from Supreme Court. Okay?
Lord,
It's the same case.
Caption need not be, my lord. It's not a remand, my lord. Simply, I was asked to, Lord, make an request, my lord. It is actually not a caption, my lord, and the remand. My lord, now your lordships directed the university, my lord. These are medical officers, my lord. Sir,
Mr. Rao.
They were asked to be treated, my
Mr.
lord,
Rao.
as local candidates, my lord.
Mr. Rao, their order was 22/8/23. It's a matter where we have received it on remand from Supreme Court. 22/8/23, we had passed an order, right?
But they are not the local candidates.
No,
They
no.
studied outside the country.
No. So,
They are claiming
what do you say?
They are claiming your reservation under in-service category.
No. So you filed counter, etc. Counter to the main petition and the IA.
Where additional counter affidavit is prepared.
When you want to file count.
Yes.
Today's matter, your lordships, my lord, the pronouncement matter, my lord, judgment matter, lordships allowed other candidates, my lord, in the same terms. 4.1b covers, my lord, the petitioners, my lord. They're both study and residence, my lord. Residence if considered because they have already uploaded residence certificates.
Last one, kindly see local candidate is one.
No, Mr. Mr. Now you are ready on this thing. We will hear on interim arrangement if you are ready. You want to? Yes, Mr. Rao.
Last one, put it tomorrow.
Mr. Counsel, tomorrow?
My lord.
Why do you want tomorrow?
I file additional counter because they studied in
Mr. Rao, learned
Last week.
counsel for the university prays for short accommodation to enable him to file an additional counter to IA filed by the petitioner seeking interim arrangement. Let the petition be. So, Mr. Day after tomorrow is fine because he shall, brother is suggesting that he shall serve a copy on you tomorrow, Mr. Rao.
Yes.
And then we will put it day after.
Yes,
Correct?
yeah.
Mark this thing, his presence. Learned counsel for the petitioner submits that the matter has not been remitted by Honorable Supreme Court, right? Not been remitted by Honorable Supreme Court. Therefore, the office is directed not to list the matter under the caption on remand from Supreme Court, inverted commas. Mr. Prabhakar Rao, Learned Counsel, states that the university shall file a counter by tomorrow after supplying a copy of the same to Learned Counsel for the petitioner. List on 31st of August 23 for consideration of prayer for interim relief. Interim arrangement.
Additional counter.
Additional counter, right? Final hearing. Good. They also we have some time. Yes.
But I'm for the respond number 2 to 4.
What is it, Mr.? See, he is reading now. Ask him, he is reading now.
This is rejecting the application, Miller.
No, we are ready.
Of course, he has to be ready.
Sir,
No, he is for the respondent.
I am for the respond number.
No, we will decide. We asked you what is the matter about, you didn't answer. Started reading, so we got an impression that you are preparing the case right away. So burden is on us only to decide. In the absence. Fine. 1 minute.
For granting the mining lease, Miller.
Not a period. Dismiss dismiss every other case. Their option will decide on that. So, grant of immunities can equal to the rejected yes to file a review description to some center NPR. 95 Supreme Court has said, well, this petition has been petitioned and dismissed, whatever. But we don't allow. See.
Book to 4.
This is against an order passed in which petition, and there are other connected writ petitions also. What happened to that? This is 771. And there was a writ petition also. 1996. So other connected is that right? Other, maybe this.
This is different.
What happened? Can we find out?
Yes. What happened to the other writ petition, connected matter? 1996 of 2001.
That what no knowledge, Miller, that for me.
See, this is a writ petition number arising from writ petition order in WP number 771 of 2001.
Yes, Miller, I have announced status, Miller.
The moment we ask you a question, you will seek adjournment, right?
No,
That's
not
the difficult.
Miller, I have no knowledge about the other writ petition, Miller.
See. Of random mining list, this online in the section 30 of NMB are actually revised and 95 Supreme Court total fee Supreme Court, like, the article of the protected could be the High Court will set him aside. Will set aside the short. He will not argue. So query please. Not mining please. Sorry. Query please. Really? And the minor mill. Gray granite. Big and the minor mill. Not a major mill. Here.
Is it a major mineral or minor mineral?
Millard?
This grey granite is a major mineral or a minor? Minor.
Minor.
And that to Telangana rules. That's what.
Minerals. Minor mineral, major mineral. She was given hypovolt. MMRD acting.
లేదా కూర్చోండి.
order deleting the excess area of 1.33 hectares, whether it was passed after affording an opportunity of hearing to the petitioner or without hearing.
Giving opportunity, my lord, and also explanation is.
No, this learned single judge has recorded a finding he is not heard. It is incorrect.
My lord, one comes.
He's what say, they have filed an appeal. Noble marbles. And
After explanation, my lord.
no, but what? 771. Srisha Geo. He is noble mineral. Respond number 4. Right. They have not filed an appeal.
No, straight or not.
So you have accepted the order passed by learned single judge, right?
Yes.
Then why are you arguing on behalf of respondent number 4 in this petition? You should say that correct. You should have you implemented this?
My lord, there is
And
my lord, there is.
you have been, Mr. Respond number 2 in the petition has been directed to invite applications for grant of prospect license. You invite application, fresh application and grant it.
My lord, there is amendment, my lord, GO number 26. Kindly see the GO number 26.
No. Arey, Mr. You cannot be permitted to assail the order passed by learned single judge. You are not the appellant, right?
No.
We don't.
You are supporting the case of the appellant or the learned single judge?
Or the petitioner in WP.
No. Please tell us your stand. You are supporting the order.
Respond number 4, my lord. I'm supporting. Who is a now appellant?
Respondent number 4 is the appellant.
Yes, I am
You
supporting.
are appearing for the?
Respond number 2 to 1 to 3, my lord.
That is state government.
Yes, state post.
So the learned single judge passed an order directing you to do certain things.
Yes.
You are not coming appeal. So to that extent, the order you have accepted. Have you implemented the order is our question.
No, already implemented, my lord. There already there is a renewal of the who is the respond number 4 is now renewal already extended. Please extended, my lord. As per the
No, but the learned single judge held that to the extent of exclusion of 1 hectare 13 hectares or whatever extent of mine is without notice to the petitioner. Therefore, the order, the exclusion is wrong. That is the order.
already here non-arts will had already given notice to the petitioner and thereafter deleted the excess area. Will kindly see.
Why we are asking, have you implemented the order of the learned single judge?
Millard, there is a already amendment, Millard, in this. GO 26. The rule, Millard, rule 12 one is the replace as follows, Millard. Kindly see the rule 12 of the Minor Minerals Act, Millard. The minor mineral concession except water.
When? 31st March 2020.
Yes, 22.
No. So you are not required to invite application under amended provision. You can secretly grant it to the appellant.
No, Millard. This is the Millard. These
It has no hearing.
Come into force. 2022.
It has come into force. The only order says that consider and decide the application in accordance with Rule 12.5 of the rules. You do it. 12.5 of the rules is subsisting rules only, as amended. That's the only thing you want. It will be done.
Open action, only for open action. So, reading the applications, open action. This 26, rule 26.
Which provision?
Millard kind of rule 12, Millard. Rule 12 supplemental shall be replaced as
rule.
The mineral concession.
Rule, which rule?
Rule 12, Millard. Amended in the GO number.
So you follow the procedure prescribed under amended rules.
Yes.
Correct. This is what is amended. Neither except ordinaries and granted the auction. We would say that in accordance with 12 as on legal file 31.
Every earlier lease subsisting or
Expired.
Excess area it has been set aside.
it's 1.34.
It is only one, they will take action under 12.
Appellant's counsel expired. B. Rajgopal.
Today, after a long time, you got a right.
Sorry. Sorry. Suddenly.
Who expired?
B. Rajgopal. Preeti's father.
What is done normally in such a case, Mr.
Notice to be ordered to the appellants.
Yes, madam. None from
Only in the Vakala, there is somebody else.
1 second. Let us, 1 second.
Vakala, somebody else.
none for the appellant. Or whatever he is for. You are GP or what?
Fines and geology.
GP. It all this thing. Learn to the operation. You have become. So that you don't have to, you don't have to change it. Yes. We know. Yes. 118.
I beg to represent Mr. Vivian Narasimha, my lord.
Yes.
My lord, this writ appeal file is filed, my lord, against the order and order of the learned secretary.
What?
My lord, this writ appeal is prepared against the order of the learned single judge in WP number 15728 of 2006, whereby the learned single judge dismissed the writ petition filed by the petitioners, my lord. The fact is that, my lord, there is a land of an extent of 100 square yards situated on the rear side of the petitioner's residence, my lord. In 1992, the housing board proposed to conduct public auction, my lord. The participants, may I audible, my lord?
Yes, go ahead, Mr. We are hearing you.
My lord, I am Rajeshwar Rao, my lord, representing VVS and VVS.
Please. Yes, Mr. Rajeshwar Rao. Please go ahead.
My lord, my lord. Originally, the writ petition is filed, my lord, questioning the action of the respondent is not considering the representations of the petitioners, my lord. The facts are like this, my lord. An extent of 1,000 square yards are on the rear side of the petitioner's residence, my lord. In 1992, the housing board proposed to conduct public auction, my lord. The participants in the public auction offered only 5,000 rupees per square yard. That public auction was not confirmed by the housing board, my lord. Thereafter, the petitioners made a representation to the housing board. Thereafter, after considering the representations, and nobody is coming forward to purchase the land, my lord, the housing board addressed a letter to the principal secretary, which is at page number 21, my lord. After calling for the petitioners for the deliberations, my lord. After due deliberations, the housing board came to the conclusion that though the market value of the market value at that time is 6,000 rupees, the housing board was fixed rupees 5,000 rupees for square yard, my lord. And the housing board addressed a letter to the principal secretary housing department dated 30/11/2000, which is page number 21, my lord. Based on this letter, my lord, the government issued GOMS number 206 dated 27/8/2001, which is at page number 20, my lord. May I read, my lord?
You read page 5 of the order of learned single judge.
My lord.
With reference to submissions.
My lord, the learned single judge came to the conclusion that the GOMS number, which enumerates that, my lord, if the land is more than 100 square yards, public auction has to be conducted, my lord.
So they conducted a public auction. You were asked to, you paid only 10% of the amount. Thereafter, the grant of time did not pay the balance amount.
My lord, because of the
And therefore,
my lord, because of the interim orders passed in WP number 198.
therefore, no direction can be given sale of property in contravention of GO dated 27/8/2020 2001.
My lord, that is,
We can't issue a writ of mandamus and there is no prayer. There is only for decision of representation. That's all.
my lord, yes, that is correct, my lord. Because of the interim orders, no finalization was done by the housing board, my lord. And the GO issued by the government of the erstwhile Andhra Pradesh, which states that in relaxation of the GO issued under in GOMS number 38, my lord.
All the options are more than. Yes.
My lord, your lordship may kindly see the GO, my lord.
No, no, Mr. All lands are more than 100 square yards, correct?
1000 square yards is correct, my lord, but different.
More than 100. More than 100.
More than 100, my lord.
Then
But
they have to be sold by an auction only. What else?
yes, my lord.
You are not challenged GOMS. Mr. You are not challenged GOMS.
206.
206.
I to admit, my lord, because the exemption.
That's the end of the matter.
Government.
End of the matter.
My lord, the GO itself says that in relaxation of the GOMS number 38, they have allotted the land to the petitioners, my lord. That is my respectful submission before your lordship.
No, allotted the land, fine, but that doesn't mean free of cost.
No,
You didn't pay anything
I am not
despite
asking for free
extension.
of cost, my lord. I am ready to pay the whatever the market value prevailing as on that date. I am ready to pay, my lord.
Purchase it in an auction. Purchase it in an auction. Purchase. Nobody prevents you from purchasing it in an auction.
But my lord, I am admitting, my lord, because nobody is participating in the public auction. They went for selling of the land, my lord. The housing board itself offered 5,000 rupees per square yard and requested the government to issue a GO.
Mr. You don't pay the amount. What can be done? We cannot pay. High Court cannot pay balance amount for you. Correct.
Because I am
Mr. You go to the housing board, do whatever you want to deposit it for housing board. Last paragraph of the order we asked you to read.
Pardon me,
Last paragraph of the order, page 5, again read it for our benefit because we have not read it. You have read it, please read.
In reply to sorry, I'm sorry.
With reference to submissions.
I'm sorry. 1 minute.
Page 5, with reference to submissions.
With reference to submissions made by the land council for the petitioner, in this case, it is to be seen that according to the petitioners, the said piece of land which is adjoining the houses of the petitioners is about 965 square yards. But however, in the counter affidavit, it is stated that the said land at measuring 1,214 square. Though on earlier occasion when the respondent board sought permission in favor of the petitioners at the rate of 5,000 rupees per square yard. But however, the petitioner did not pay the said amount at the rate as fixed by the government pursuant to the communication sent by the respondent board. Though the petitioners have paid partial consideration, but they did not pay the balance amount even in the extended period of time during the year 2001. It is stated in the counter affidavit that the amount paid by the petitioner was refunded to them, even as per Rule 29 of the AP Housing Board Rule 1959, framed under the AP Housing Board Act 1956. Disposal of the property of the board by sale or lease shall be by public auction. In that view of the matter, and as the petitioners themselves failed to pay the amount fixed in GORT number 206 dated 27/8/2001, no direction can be given for sale of the said land. In that view of the matter, I do not find any valid ground for grant of relief as paid for. My lords may kindly see the para number 20.
So did you pay the amount? Is it your case that you paid the balance amount?
My lords, kindly see
Was it not,
our request.
Mr. Two things, you did not pay the balance amount within the time limit. That amount was refunded to you. End of the matter.
Yes, correct. Because of the stay granted by this honorable court in WP number 198 of 198/65 of 2001, our request was not considered, and I filed an application on 25/2/2006, my lord, which is at page number 23. In this connection, we have to state that we are ready to pay the balance land cost as the writ petition.
Mr. Counsel, Mr. Rao, we will advise you not to invite an order by this court. We are ready to pass. You will get in next 10 minutes. But what we say that if you are ready and willing to pay the market value of the land, approach the housing board.
Well, I have approached the housing
board. No. Fine. Then if you want us to decide, we will decide. We are suggesting you don't ask this court to adjudicate, because then their only option will be left is 136, Article 136. Better we are suggesting that you approach the housing board with whatever you are offer and let them decide. Instead of seeking a stamp of approval, if you want to, we will pass an order right away,
No,
subject to what you argue.
I'm not saying that, but I'm apologizing, my lord, because
No apology, Mr. Why? There's no apology. It's a suggestion from the court. We will hear you, whatever you have to argue. Yes. So
because according to the counter affidavit, my lord, I filed a representations to the housing board on 25/2/2006 itself, my lord. Because of the stay granted by this honorable court in another writ petition, the sale was not confirmed by the housing board, my lord, government, my lord. Therefore,
which order of stay? Where is that order of stay?
that is that order is not there, my lord, but because
Ah,
I have
not there.
order.
You did not bring it to the even Mr. Notice of learned single judge. You are arguing in an intra-court appeal without bringing it on record.
Your
Couldn't take
lordship
note of oral submission.
Your lordship may kindly grant two days time, my lord. I will come with the hour.
No time. 2008, 15 years. Still we are, Mr. Rao, still we are telling you better to go to housing board with your offer that you are willing to pay the market value. Housing board will decide. Or you want an order on merits, we will pass an order on merits. There is no subsisting right in you claim that it should be allotted to me only.
My lord. Because after the disposal of this writ petition, my lord, I filed an application.
Not getting it. What
Mr.
we are not
Rajeshwara,
My lord.
if we adjudicate, then once for all, your this thing will be sealed with housing board. We'll have to only hold that it can only be sold by public auction because the extent is more than 100 square yards.
Yes, my lord.
So if we follow strictly GO 206, it cannot be given to you. It can only be by way of a public auction. For that reason, we are suggesting you approach the government, the housing board, with make some valid, genuine offer. Maybe they will consider. If you want adjudication, we will simply have to confirm. Then they will not even look at you. Thereafter, you will not be able to climb the steps of housing board.
My humble submission before your lordship is, my lord.
No, Mr. Rajeshwara, let us be one thing clear that 5,000 cannot be accepted now. Much water has flown, 22 years has flown.
I don't see, my lord, that now the
So that
present
is why we are
market
saying
is high.
don't harp on the 2001 rate of 5,000.
That's gone over. He has received the refund. Anything else, Mr. Rao? Anything else?
This my only submission.
You told us two submissions that there is after you had submitted a representation to housing board and there was an order of stay in some writ petition. Because of that, the representation could not be considered.
Yes.
Anything else?
My humble submission before your lordship meeting. GOMS number 38, which was earlier issued by the government of Andhra Pradesh, by relaxing that judgment, the allotment was sales were made. That is only my submission before your lordship.
All right. Which GOMS?
GOMS number, which is there in the GO.
Where is which page of the paper book?
20, my lord. Page number 20, my lord. May I permittably read, my lord? May I read, my lord?
No, we have read it, page 20. So what is GOMS? So what is the submission? We have read it, Mr.
My lord, in the last line, my lord, in relaxation of the GOMS number 38, my lord. Last but two lines, my lord. In the circumstances reported by the Vice Chairman and Housing Commissioner AP Housing Board in his letters read above, government after careful consideration hereby permit the Vice Chairman and Housing Commissioner AP Housing Board to sell the land available on rear side of the house bearing number so and so Amirpet to the adjacent house owners at the rate of 5,000 per square yard and also shown below, subject to the withdrawal of court cases pending in the court and also in relaxation of the orders issued in GOMS number 38.
Fine. So therefore this, at the rate of 5,000 rupees, it should be granted to you right away. This is the argument.
I am not asking, my lord. The prevailing market as on today, my lord, we are ready to purchase the same.
All right. Mark the presence. This intra-court appeal is filed against an order dated 8th of October 2007 passed by learned single judge by which writ petition preferred
I have not, though the check was issued and refunded, the check was returned to the housing board, my lord. The amount is lying with the housing board, my lord. Your lordship may direct the housing board to pay the amount, my lord, with interest.
You can go and approach it.
Approach, and housing board didn't say, this is not a prayer for refund. Yes, rate appeal, yes. See what we are taking, 3% would have refunded. Like it's like what we were getting that we will be going. Instead of what we did. How difficult?
I beg to represent M. Ramarao, my lord. I beg to represent M. Ramarao. He instructed me to take adjustment as the compromise talks are going on.
I've taken
See
instructions.
his
from my-
smile on his face tells that this statement is
My
incorrect.
instructing counsel tells me, my lord, there is no such instruction, my lord. That's what I told him also.
Go ahead. Go ahead.
Lord, I'm not his office, my lord.
Don't appear then. Don't appear. Yes, Mr. Senior Counsel. Please.
Yes,
Sit down.
and single judge, my lord.
You
this
can
is a
go,
case-
Mr. You are not concerned with the case. Please leave the court. I mean, what we are saying is that you can sit here, but and watch what is the order and convey to your friend, but you can leave also if you want to. The choice is with you. It's a public place, we cannot say. You want to observe the proceeding, right, and to communicate what order has been passed. Supposing if it is allowed, you will say that, no, mark my presence. No, you will not say, right? Even if this appeal is allowed, you will not say that mark my presence. Correct?
My instructions are that.
No, nothing, no instructions. We are not bound by those instructions. He has controverted it.
No, but my instructing counsel.
Speak.
my lord,
We are not saying he is saying in your presence. You tell him. We are not adjourning old matters. Don't take this onerous task of seeking an adjournment, which is nearly an impossibility in this court. Yes.
Let me give the facts, blood in brief. But there was a provision, section 5, capital A, Malad in 1971 Act, regularizing Malad unregistered sales. But there was a provision, Malad, because that has been now repealed. So 5A, Malad, in 1971 Act provides for Malad regularization of unregistered sales, Malad. So we had applied for, respondents here in Malad have applied for, and Malad got the certificate, Malad, of regularization. That was challenged, not by the party, Malad, who sold it to us, but another person, Malad, his own brother, claiming himself to the agreement holder. So he filed the appeal. We challenged, Malad, appeal was also provided in section 5B. Malad, we challenged Malad in the appeal saying that you have no locus standi to challenge, original owner has not challenged, he was the party, he has not challenged it. Then, Malad, the appellate authority has not decided that issue of the locus standi, Malad, of the appellate to challenge the order. But when we last, Malad, appeal on merits, Malad, he has gone into the merits without deciding the issue of the locus standi. We filed the revision. Before the revisional authority also specifically this ground has been raised about the locus standi. Revisional authority, Malad, under section 9 has also not gone into this. But the revision also, Malad, dismissed. We filed the writ petition. But when it came up before the learned single judge, Malad, looked into these aspects, Malad, saying that before the original appellate authority and as well as the revisional authority, we raised the issue and as it has not been decided.
Order of remand.
Order of remand, Malad, but only thing I need to tell you, Lordships, now 71 Act has been repealed. 2020 Act doesn't have the similar provision. But it has got section 16 of the repealing 2020 Act says the pending disputes will be transferred. But it may not be strictly may not be pending, but and the writ appeal and the stay. But it would have been pending before the RDO. There is no such jurisdiction which has been given to the appellate. No appeal is provided. No 5A also. No regularization also now in
the proceeding under 71 Act would continue, right?
That's how, my lord, under section 16, there is a special tribunal. Special tribunal, my lord, can be asked to decide the issue.
Yes, yes.
On remand.
Correct.
Special tribunal has been defined.
Yes. Yes, madam, right. Lordship,